and welcome to Case Closed. I'm Charlie Langton, your host. We'll soon go inside an actual courtroom in the Warren District Court to see real small claims cases in action. Now, under Michigan law, small claims cases may be brought by individuals seeking $3,000 in damages or less. Neither side may be represented by an attorney in small claims court, and the judge's decision is final. Now, let's take a look at the first case, the case of the bouncing check.
Mr. Roberts, tell me what this is all about.
This case is about a loan which was taken out back in, November of '09. Was due on November 20th of '09. At that time, the collateral for these loans are checks.
Right.
We extended the loan as long as we could by law to 31 days. Then the check was put in. When the check was deposited, we were returned with a account closed statement from the bank. That was on 12/15/09. 30-day letter was sent out to the client, okay, saying that we need to wrap this thing up in 30 days. Please repay us the amount of the $676.45. There were different agreements. We had 7 different conversations with the client, and we entered into one agreement that was supposed to start on February 1st of 2010. No payment was made and no one showed up. And so then now with where we're at now is we're suing for 2 times the amount of the check plus the check, the $250, and the $25 of the bounce check fee as per Michigan law.
How much was the loan for?
$676.45.
$676.45?
Yes, sir.
The check was for how much?
$676.45.
The exact amount.
That's with the fees, the original.
Yeah, 600
The original loan's $600.
Okay.
There's 70. I'm sorry, and then there's $76.45
interest.
Okay,
of
so
state fees and interest.
So you're suing for $600 plus $676.45 times 2, correct?
Correct.
Which is $1,352.90, right?
Okay, the original amount is $676.45 plus you get
That's
2 times the original amount, which is $1,352.96
Okay.
plus $250.
So $676.40 times 3.
Correct. But the way the law says, it says the original amount plus 2 times the original amount is the way that it's stated.
Right.
It's really 3 times the original.
This case involves a very specific law that allows somebody that loans money to recover 2 times the amount if that check bounced. Let's see if the defendant has any excuses here.
Ms. Kelly Manise, what do you have to say?
I don't have the original paperwork, but the loan did go on for a couple years. I've known Wayne for quite a while. I was married at the time. I did take the $600 loan out, and I did make my payments of the interest of the $76.
You did what? I'm sorry.
I made the interest payments on the $600 original. It was a $76 and some change interest every biweekly when I got paid, and I was working at the time.
Right.
Unfortunately, I got divorced. And we continued the loan, and I did not know this, but at the time, my husband at the time did close the account and didn't realize I haven't seen him since, and realized I was keeping up with the $76 interest, and Wayne and I did have a few discussions regarding agreements on this, and I was hoping back in February that I could pay the $600 back, or the $675, whatever I own. Unfortunately, income tax, but because of my ex-husband, things did not go that way, and currently because of a health condition that I've had for a few years, I'm not able to work due to tumors on my throat. So I just I do want to pay this back. I'm not working, and I'm not getting disability yet, but I am on FIA, and I'm applying for cash assistance, and I just want to get this paid. But I have 4 children. I'm a single mom, and I'm just doing the best I can right now, and I don't disagree with him, but we did have several loans. I've kept in contact with them and tried to stick with all the interest as far as the biweekly 76. I've always either my son or I have made those payments to him, and this has been a long outstanding loan that I've kept it in good standings. And just unfortunately, I got divorced and got ill, and things happened, and now I'm just trying to get it. I was served with this by a police officer, and then the court date, and
well, it wasn't a police officer.
Well,
it looked like a police officer.
Looked like one at my door.
It wasn't.
So, but I don't disagree. I'm a little worried about the 2304 like I said, as far as the $76 interest every other week, I did pay that pretty much all the time. And when I was behind, I'd make the double payment. As we did agree on, I did maintain contact with him and let him know the situation as far as the divorce, as far as the cancer and the job. And then what happened is when I was working, they were garnishing my wages for medical billing, from past medical bills due to all my surgeries that I have. And that's when I got really behind because of the garnishments that I was taking out from the hospital.
Well,
So I'm not disagreeing, the 2304 is just a little steep for me.
well, I'm sure it is, but that is not anything that I can use to change what the judgment should be.
Well, the defendant does have a good emotional excuse, but unfortunately not a very good legal excuse. I don't think this is going to be very difficult for the judge. Let's see.
You owe the money. You know, the plaintiff is legally entitled to it.
I understand. I just would like to know if I would like to come to some sort of, plus my child support, which is another issue that I wanted to bring up. I was getting child support weekly, which was very good, that I was able to maintain this even after out of work due to medical reasons. And my ex-husband just moved back from Las Vegas unemployed, and he's supposed to be paying me.
I wonder why.
He's supposed to be paying me $200 a week, according to friend of the court in Mount Clemens, and he is not making his payments. And now they're have a warrant for him, so he is my income as far as that goes. And even if that came in, I would make some sort of arrangement with Wayne to keep, to get this situated, because this was not what I had planned, and he understands that. I did keep in touch.
Well, there's nothing I can do, not much to say. I'm sympathetic, but you owe the money.
I know, I do. I'm
And,
not disagreeing.
maybe you can work out something.
I'd like to work out a payment arrangement as far as, we do have a friend of the court hearing coming up as far as motion to, hearing motion or for the ex-husband, and that's when they're going to decide with him what he has to do as far as arrearages and $11,000 in child support.
But that is not anything that I decide, any payment.
No, I know, that's just my income.
Court's going to enter a judgment in favor of the plaintiff, the amount of $2,304.35. The court will enter that cost, consisting of a $65 filing fee and a $23 service fee, bringing the total amount of the judgment to $2,392.35. I hope we can work something out. Ms. Kelly-Miniz, that's about all I can say.
Yes, a very easy case for the judge to decide. Let's see if the next case is as easy. That case being the forgetful futon.
All right, this is your case, I believe, Ms. Mahone. What are you asking for?
For $296.79.
$296.79?
Yes, plus
Why are
court
you-
costs.
I'm sorry, what?
Plus court
Well,
costs.
yes, plus court costs. Why are you entitled to $296.79?
Back in April 2009, Mr. Wilson purchased merchandise originally on a secondary financing company that we have.
On a what?
Secondary financing.
I don't know what that is. What's secondary financing?
Well, we have our main art van charge. You get approved through. If you don't get approved through that, it goes through a second company,
Okay,
which back then I believe it was beneficial.
okay.
She had to originally sign her contract, which wasn't signed, but she already received her merchandise.
Well, why did she receive her merchandise from you if the financing didn't get approved?
That's what we like to know also. It was a glitch in the system.
I guess so. What does she have?
I'm not for sure what it was, a bedroom furniture or something like that.
Couldn't be that much, $296.79. I mean, what kind of furniture can you get for that price? Not a whole lot, right?
No, not a whole lot.
But it matters, I suppose. So you want the money, the value of the furniture, right?
Yes.
So whatever the defendant got for $296, it seems like she didn't pay for it. Let's see if she did.
Well, Ms. Wilson, let's start with you by asking this question. What do you have? What furniture are we talking about?
It was a full-time.
It was a what?
Full-time.
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 What is that?
Like a little couch, but not a full couch.
Okay, a little couch.
Yeah.
Is that a yes?
Yes.
Okay, what's your defense to this? You have it, right?
Yeah.
Did you pay
I have
for it?
No, I did make a couple of payments, and then I lost contact. I moved, and I never really kind of received nothing and kind of forgot about it.
Okay, well, now you remember, right?
Oh, yeah, when I got the paper in the mail, yes.
Do you dispute that you owe this, or what, do you have a defense to this?
No. I mean, I did receive it. I didn't never finish out signing any paperwork or received anything like monthly to make payments. It was just kind of in the head, made a few payments, and after that, kind of just forgot about it.
Oh, you had it in your house, that this futon or whatever it is.
In the basement,
How
and
could you-
didn't kind of
What'd
use
you
it
do?
anymore.
Don't go in the basement and forget about
Not
it?
often.
Ah, so the futon was in her basement. She forgot about it. No.
Ma'am, you've got to pay for it, okay?
That's fine.
Well, evidently it's not, because you haven't paid for it, or at least forgot about it. Do you dispute the amount, $296.79?
I'm not sure exactly how much I owe, but if that's what they say, that's fine.
All right. Well, I guess it's not a hard case.
No, not at all. I mean, I did receive it. Not sure of exactly what was the left amount that I needed to pay, but
The court's going to enter a judgment in favor of the plaintiff, the amount of $296.79. The court will add to that cost, consisting of a $25 filing fee and a $35 service fee. We got a $20 motion fee here, too. The court will add that to cost, bringing the total amount to $376.79.